we finished at lunch with Mr. Brockman continuing his cross-examination. Mr. Brockman and Mr. Callanan, can you both hear me okay?
Sure can, Your Honor.
Yes.
Okay, great. Then it looks like everyone's here and we're ready to go back on the record. Mr. Brockman, you may ask your next question of this witness.
Thank you, Your Honor. And Professor Callanan, in your opinion, the legislature's decision to enact SB 824 during the lame duck is evidence that the legislature believed the governor would not have signed SB 824 in the form it was ultimately enacted, correct?
I would say it's consistent. It's consistent with the hypothesis that they did not expect the governor to sign the form that they preferred. And my understanding is that that was well known at the time. But I hesitate to use the word evidence in a strong sense. I would say it's consistent with that hypothesis.
That would be the reason that political scientists would most expect the legislature to act in November, correct?
I'm not sure if I would put the emphasis on most. There may be some other reasons that you could suggest to me that would be of equal import, but it's certainly one of the reasons that it's not surprising to find the legislature acting in the lame duck.
Okay, so you disagree that it would be the most important consideration from the point of view of political science?
I simply mean to say something more modest, which is that sitting here, I wouldn't exclude the possibility that there are some other more important reasons. But it is a reason that the legislature might be expected to act in the lame duck.
Okay, Professor Callanan, you recall giving a deposition in this case in January of this year?
Yes.
Okay, and do you recall that I asked you during that deposition if it was your opinion that the legislature's decision to enact SB 824 during the lame duck was evidence that the legislature believed the governor would not sign SB 824 in the form that it was ultimately enacted? Do you recall that question?
Generally recall that.
Okay, Ashley, let's bring up page 115 if we can of Professor Callanan's deposition from January of 2021. And Professor Callanan, focusing your attention on lines 2 through, for the time being, let's say 7. Do you see that I asked you this question about whether the legislature's decision was evidence of its belief that the governor would not sign SB 824? You answered yes, and then your answer continues, and we'll look at that in a moment. But does this refresh your recollection that you answered that this was evidence of the legislature's belief?
Yes, it looks like I had more to say, but yes.
You did indeed, and I do want to show you the rest of your answer. So if we could scroll down a little bit. And as you testified today, you said it may not be the only reason, or that's not the only reason. But you went on to say it would be a reasonable explanation from the point of view of political science. And, or to just put it this way, that would be the reason political scientists would most expect the legislature to act in November. Do you see that?
I do.
And you don't disagree with that testimony, do you?
No, I suppose I'm leaving open the possibility that someone could propose to me a reason that would be even more compelling.
Okay, but sitting here today, you don't have one.
Sitting here today, yeah, consistent with what I just said. Sitting here today, I'm not prepared to indicate some other reason that political scientists would give that would be more important than this one.
Okay, fair enough. And so the enactment in the lame duck over the governor's veto is an indication that the Republican supermajority had a policy preference that it did not want to pass what it considered to be a watered down voter ID law. Is that correct?
Yes, it's consistent with that hypothesis.
And so the legislature's decision, or the supermajority's decision, to pass SB 824 over the governor's veto during the lame duck is also consistent with the hypothesis that the supermajority intended to pass a voter ID law that was more restrictive than the law that would have been enacted once the new legislature was seated in 2019, correct?
It depends what you mean by restrictive.
Okay, so in our last Q&A, you, I think, agreed with me that the legislature's course of conduct was consistent with the hypothesis that they did not want to pass what I characterized as a watered down voter ID bill, right?
Yes.
Okay. And so is that behavior by the legislature also not then consistent with the hypothesis that the legislature preferred a form of voter ID that was not, quote unquote, watered down?
Yes.
And the form of voter ID that would have been enacted when the legislature was seated in 2019 would have been more watered down than the form of voter ID that was enacted during the lame duck session, correct?
Actually, I think as I said in the deposition, there's no guarantee that any form of voter ID would have been passed in the following biennium, as far as I understand. In other words, there was no guarantee that the legislature and the governor would have come to any agreement.
Okay. If any voter ID law had been passed in 2019 when the new legislature was seated, it would have been more watered down than the version of SB 824 that was enacted by the supermajority over the governor's veto in 2018, correct?
Yes, I think that's a fair counterfactual, given the fact that the governor has said that he wanted other forms of qualifying ID, other forms of compliant ID, which I describe as a more flexible law on that metric in
Right.
my December report.
Right. So the law in 2019 would have been more flexible, would have included more forms of qualifying ID, assuming some version was enacted.
If some version was enacted, that would be a reasonable prediction to make, or sort of counterfactual inference to make.
Okay. Now, with respect to the version of SB 824 that ultimately was enacted, we don't know for sure whether that was consistent with the voters' policy preference, because the constitutional ballot referendum did not provide voters with proposed implementing legislation. Do you agree with that?
Yes, all we have is the statements of policymakers, claiming that they had a mandate, that they understood themselves to be acting pursuant to the will of the people. But I'm not aware of any. Ultimately, what your question would be getting at was survey data. Do we have any survey data that indicates exactly what form the people of North Carolina wanted the law to take? And I'm not aware of any survey data of that nature.
Right. And you're not aware of the General Assembly having conducted such a study or survey, are you?
No.
And you did not conduct such a study or survey in this case, correct?
No, I wasn't asked to inquire into that question.
Okay. Professor Callanan, I'd like to turn now to, I think, the second topic that you discussed with counsel for the legislative defendants this morning, which is your evaluation of the structure of SB 824 as it compares to other voter ID laws. And it's your opinion that the General Assembly, in enacting SB 824, took a comparatively non-strict approach to dealing with voters who lack a form of qualifying ID. Is that correct?
That's correct.
And in your analysis on that subject, you observe that SB 824 is classified as a non-strict voter ID law by the NCSL, correct?
That's right.
And in your report, you state that SB 824's treatment of voters who lack a qualifying ID is more permissive than the laws of several other states that have voter ID laws. Is that correct?
That's correct.
And I believe in your report, you state that presented with various models from other states, the North Carolina General Assembly passed over more rigid approaches in favor of the approach taken in SB 824. Is that correct?
Yes.
But you are not, as I understand it, offering the opinion that the General Assembly actually considered and weighed the merits of each of those other state laws in deciding how to shape SB 824, are you?
That's right. I think we had this discussion in the deposition. We talked about the ambiguity of a passive presented with. So you could view that phrase as me making some claim like that they were presented with, data from all these different states that I know of some presentation, or you could understand presented with as sort of a way of saying, well, look, in view of, given in the presence of these other models, here's how they acted. And I meant it more in that latter sense. I'm not aware of any presentation that was given to the General Assembly that, or the leadership of the General Assembly that that outlined all the details of the other states' laws. It would be certainly, we certainly do have evidence that there, as we discussed, there are mentions in journalistic accounts of other state laws. But we don't have evidence of anything like that I'm aware of, anything like a comprehensive comparative analysis.
Okay, fair enough. And you're also not offering the opinion that the legislature intended to enact a law that would meet the NCSL criteria for a non-strict voter ID law, are you?
I'm not offering the opinion that they intended to meet that criteria, or even that they necessarily knew about that classification system. They clearly intended to produce a voter ID law that allowed voters without ID to vote, because that's the law that they produced. But whether they had that particular classification scheme in mind, I don't know.
Okay. And counsel for legislative defendants asked you earlier today about a comparison between SB 824, which the NCSL classifies as non-strict, and the Indiana voter ID law, which the NCSL classifies as strict. Do you recall that testimony?
I do.
And you testified on direct that the Indiana law, which is classified as strict, was upheld by the Supreme Court in the Crawford decision. You recall that as well?
I do.
Okay. You're aware that that Supreme Court case in Crawford was not an intentional racial discrimination case, right?
Actually, I don't know every detail of that litigation.
Okay. Did you consider the nature of the claims that were being advanced by the plaintiffs in Crawford for purposes of forming your opinion in this case?
I didn't read the I didn't read the briefs of plaintiffs in the Crawford case.
Okay. Would it be relevant for purposes of comparing the Indiana law to SB 824 in the context of this case to know whether or not the Indiana law was being challenged as intentionally racially discriminatory?
It wouldn't matter in terms of how the structure of the laws compare. In other words, the nature of that challenge wouldn't have any bearing, wouldn't change what the actual structure of the Indiana law is.
Right. It wouldn't change the fact that the Indiana law is categorized as strict, is what you're saying.
It wouldn't change the structure of the law, and therefore it wouldn't change how the NCSL characterizes it.
But if it was upheld because, well, if it was upheld in a case where it was not challenged as intentionally racially discriminatory, it wouldn't be an apples to apples comparison with this case, would it?
I don't know what you mean by apples to apples. I'm sorry to, I hope that doesn't sound pedantic. it is apples to apples in the sense that it's one voter ID law compared to another voter ID law. But I recognize that the details of the claims that plaintiffs made in the two different cases would obviously be different in some respects. But that wouldn't change the underlying comparison of the two laws.
So when you were testifying about the Indiana law this morning as compared to SB 824, you weren't intending to imply that just because the Indiana law was upheld by the Supreme Court, that this law should be upheld by this court, were you?
No, that would be a jurisprudential determination, not a determination for a political scientist to make.
Okay. You're also aware that HB 589, the prior North Carolina voter ID law, was also considered non-strict by the NCSL, right?
In its amended form, that is correct.
Right. And you know that despite that designation by the NCSL, HB 589 was found to be intentionally discriminatory, correct?
I did know that, yes.
Okay.
There are
And
differences between this seems relevant to mention that there are differences between the reasonable impediment provision under the revised 589 and the reasonable impediment provision under 824. Among them, 589 allowed officials to make judgments about whether the reasonable impediment cited was nonsensical or simply degraded the law, and it also required either supporting ID or matching information, whereas to file that reasonable impediment form, whereas 824 does not.
okay, but I think all I'm trying to ask is whether you're offering the opinion that just because a voter ID law meets the NCSL definition of non-strict, that doesn't somehow prove that the law was not enacted with discriminatory intent, right?
No, it would not by itself prove anything.
Okay. Now, you've also testified, I believe, in a prior deposition that it would be inconsistent for a legislature intent on passing an intentionally discriminatory law to include provisions for free ID and to include provisions for reasonable impediment options for voters who lack qualifying ID. Do you recall that testimony?
Could you repeat that question?
Of course. I believe you testified in a deposition that it would be inconsistent for a legislature intent on passing an intentionally discriminatory law to include provisions for free ID and provisions for a reasonable impediment option. Do you recall that?
I don't recall giving testimony that was that simplistic.
Okay. Ashley, let's bring up from the 2021 deposition, page 150, and we'll take a look at lines 19 to 25. And Professor Callanan, does this refresh your recollection that you testified it would be inconsistent for a legislature intent on passing an intentionally discriminatory law to include provisions for free ID and provisions for a reasonable impediment option?
It does refresh my memory. So the context of my exchange with Ms. Moss, if I remember correctly, which you were paraphrasing here, was, if I recall, her question was, as I recall, her question was asking whether it was consistent. I had recalled my exchange with her being about the racial categories of ID holders, the racial demographics of ID holders.
Okay. Ashley, let's take a look at page 147 of the deposition, if we could, please. And if we look at starting at line 14, Professor Callanan, I believe this is the exchange you were having with Ms. Moss. She asked you, apart from the choices of IDs, is there anything else about the structure of Senate Bill 824 that would be inconsistent with a legislative intent to make it more difficult for minorities to vote? You answered, well, certainly a legislature that was determined to do that would consider dropping a reasonable impediment option, would consider either a more restrictive or non-existent. They need to eliminate any free ID programs. Do you see
Yes.
that?
Yes, and now this is refreshing my memory. So my view here is actually probably more nuanced than I led on when I answered simply yes to your paraphrase in the deposition. So the question essentially is, would a legislature that is bent on making it difficult to vote, would a legislature that's bent on making it difficult to vote have a reasonable impediment option? Would a legislature that's bent on making it difficult to vote provide free ID so that people could use the free ID to vote? And my answer was no. A legislature that has that determined objective would not be expected to do those things, all other things being equal.
Okay,
What
but
I don't mean to say is that simply because there is, for example, a free ID program in a hypothetical voter ID law, simply because they have a free ID program, this counts as evidence that they're not trying to discriminate in some other way. So I hope that helps build out that yes to your paraphrase in the deposition.
it does, and I appreciate that clarification. My follow-up question to you, though, is you're aware that HB 589 included a form of free ID, are you not?
I am.
And you're also aware that HB 589 as amended included a reasonable impediment provision?
Yeah, I believe we discussed that. And as I said, it's perfectly, it's not difficult to imagine a hypothetical in which you have a law that is discriminatory in any number of ways, right? But the legislature, has a free ID provision. The free ID provision in and of itself doesn't tell you that you definitely don't have a you definitely don't have a discriminatory law.
Right,
It
and
is
neither does the
suggestive. Yeah, it is
and neither
suggestive though. I'm sorry. Could I just finish that?
please.
I left too big of a gap there, so I understood why you didn't think I was done. It is suggestive, however, of what I was saying to Ms. Moss, which is if a legislature is bent on making it difficult to vote, if that's their goal, then you wouldn't expect a free ID provision, all other things being equal.
Right, and the converse of that, I suppose, as well, would be that the reasonable impediment provision in and of itself doesn't tell you that the law is not intended to discriminate in some other way.
That's correct.
Okay. Now turning back to your evaluation of the flexibility of SB 824, you evaluate the flexibility of the law basically on three dimensions. Is that correct?
I don't use the word flexibility for all three, but I speak of the strictness of the law with its treatment of voters who don't have ID, and I speak of the flexibility of the law in its list of compliant IDs, and I speak of how accommodating the law is for voters who lack ID.
Okay, and that flexibility and strictness and how accommodating it is, those criteria, you're not aware of any academic study that uses those three specific criteria to evaluate voter ID laws, are you?
No, I'm not. The most often used taxonomy is this one that comes from the NCSL. I was asked to compare the structure of the law to the structure of other voter ID laws. I'm actually not aware of any study that attempts to do that on a sort of reasonably thorough basis. The NCSL is only comparing this one facet of the law. So I compared the law on these, you could say, these three axes, these axes of variation across voter ID laws. They vary with respect to how they treat you if you don't have ID. They vary with respect to what IDs are compliant, and they vary with respect to what they do to accommodate people who don't have ID. So those are the three axes that I used.
Right. And my question is just, that's something you came up with for this case. It's not drawn from the literature or from the NCSL, correct?
That's right. The second and third are not drawn from the NCSL.
Okay. The second factor we were just talking about, I believe, is the range of compliant IDs that are offered to voters under SB 824. Is that correct?
Yes.
And on that axis, your opinion is that SB 824 is moderately flexible in its approach to qualifying IDs. Is that correct?
Yes.
But your concept of flexibility does not address whether the range of acceptable IDs increases the number of voters who possess an acceptable form of ID, correct?
That's right. That would be moving in the direction of an impact analysis, whereas I'm comparing the structure of the laws.
Right. And so your analysis also does not speak to the number of voters who possess any particular form of the IDs that are available under SB 824, correct?
That's right.
And you did not see any evidence in forming your opinions that indicated that the North Carolina General Assembly conducted the sort of flexibility comparison that you undertook in your report, correct?
Certainly not as thorough as I undertook.
Okay. And you're not aware of any evidence to suggest that the General Assembly was evaluating the experience of states that chose to accept one particular form of ID versus another when they were deciding what menu of IDs to include in SB 824, correct?
Not specifically. I mean, it would be normal for a state legislature that's passing a particular kind of legislation to consult other models. That would be, within the range of normal expectation for political scientists. This is why you have, for example, the institution of the model bill, the model legislation. But I don't have any specific references regarding, these sort of comprehensive comparisons being made.
Right. They didn't essentially do what you've done in your report and then pass the law, right?
Not that I know of.
Okay. Okay. If they did, they probably owe you some credit.
Or I owe them some credit.
Either way. All right, let me shift gears and ask you about another of the opinions you testified to this morning. It's your opinion that the forms of ID that the legislature chose to include in SB 824 does not show a preference for IDs held disproportionately by white voters, correct?
That's right.
Okay. But you're not making a claim about the extent to which the inclusion or exclusion of any specific form of ID under SB 824 impacts the overall racial disparity in ID possession rates in North Carolina, correct?
No, that would be an impact analysis, or at least that would be, as I mentioned earlier, that would be part of an impact analysis.
Okay. And the data that you report for the forms of ID that you analyze does not tell you the extent to which including these forms of ID impacts the overall racial disparity in ID possession in North Carolina, right?
That's right.
Okay. And it also doesn't tell you, well, actually, let me take a step back. So your understanding that the driver's license or DMV issued ID is the most commonly held form of ID in North Carolina?
I don't have data on that, but it certainly seems like one of those, you know, obvious points.
Sure. And the data that you analyze on the different forms of ID included under SB 824 doesn't tell you anything about whether that is the only form of qualifying ID that a voter possesses, correct?
That's right.
Okay. And you're not offering an opinion in this case that the legislature understood or believed that including these forms of additional ID in SB 824 would reduce the overall racial disparity in ID possession rates in North Carolina, correct?
No, I'm not testifying as to what they knew in particular.
Right. So the demographic data that you considered is, in your opinion, the kind of data that would have been available to a hypothetical state legislator if they were looking for such data, correct?
Yeah, that's right. If you imagine if you had you could, you know, a precise surgeon, you know, think the phrase surgical precision. If you had a precise surgeon who was looking to craft an ID list, a schedule of compliant IDs, and what this hypothetical legislator is trying to do is choose IDs that whites are more likely to have than minorities, or that among the holders of which minorities are underrepresented. So I was essentially, this data is useful for evaluating sort of that hypothesis of the hypothetical legislator. But do I know whether there was any legislator actually, you know, armed with that data trying to do that, or trying to do the opposite? I don't know.
Right. You're not aware of any evidence that the General Assembly considered the data that you analyze in your report.
Not specifically.
Right. Okay. Um,
I'll only say that none of the data that I analyzed is private data. It's all publicly available data.
Sure. But you're not aware of any specific evidence that this publicly available data was on the desk of a particular legislator or before the leadership of the General Assembly, correct?
That's right.
And you're also not aware of any evidence that the General Assembly requested these data from any other department or agency of the state when it was crafting SB 824, correct?
That's correct.
Shift gears now and talk about your opinions on voter fraud and voter confidence. You referenced this morning in your testimony a case in Virginia where the vote was tied and the winner was decided by a random drawing. Do you recall that?
Yes.
And isn't it also the case that in that race there were a couple dozen voters who voted incorrect ballots because election officials gave them the wrong ballots? Are you aware of that?
Not specifically.
Okay. Ashley, let's bring up, I think it's what we've marked as PX99. I think this is going to be a Washington Post article that I think is referring to the same election that you were testifying about this morning, but you tell me, Professor Callanan, is this the same race you were referring to?
That looks like it. Yep.
Okay. And if we scroll down just a little bit more, oh, sorry, it's just a little bit too far. There we go. And Professor Callanan, do you see there's a sentence that begins now, and it says, now a review of voter registration records and district maps by the Washington Post has found more than 24 voters, enough to swing the outcome of that race, cast ballots in the wrong district because of errors by local elections officials. Do you see that?
I do.
Okay. And so when you were referring to this election, you weren't suggesting that the race had been tipped by fraud, were you?
No, I believe what I said is that this would be an example of a race where one fraudulent vote could have tipped the outcome.
Right. And it's also an example of a race where a couple dozen mistakes by elections officials could also have tipped the outcome, correct?
That's right.
Okay. And you're not aware of any credible allegation that a fraudulent vote tipped the balance in this race, right?
No.
Okay. Ashley, we can take that down. You also mentioned the Heritage Foundation data set on voter fraud. Do you recall that testimony?
I do.
And is it your understanding that the Heritage Foundation data set includes 13 state and federal prosecutions of voter impersonation from 2004 to 2017?
That sounds correct.
Okay. And you don't have any reason to think that the Heritage Foundation would have omitted other examples of in-person voter impersonation, do you?
Omitted other prosecutions? Do you mean, Mr. Brockman?
Yes, that's a fair clarification. Yes.
No, I have no reason to believe they would have omitted any other prosecutions.
Okay. And to your knowledge, those prosecutions were not in North Carolina, were they?
I don't specifically recall.
Okay. And you also testified a little bit about, I think, what you referred to as widespread voter impersonation fraud, like the example you gave from Brooklyn. Do you recall that?
Yeah, the term normally used is coordinated.
Coordinated. Okay, thank you.
So it's not, so we make a distinction between coordinated and casual. Casual might be, um, mom's in bed, sick. I'll go vote for her.
Hmm.
Um, Coordinated would be obviously something on a larger scale.
Right. And do you identify in any of your reports any examples of coordinated in-person voter impersonation in North Carolina?
No,
Okay. And you're not offering the opinion that in-person voter impersonation fraud in North Carolina has changed the outcome of any elections, are you?
no.
Um, and in fact, I think in your reports you identify 3 cases or credible allegations of in-person voter impersonation fraud in North Carolina in recent history. Does that sound right?
Yes,
Okay. And you would agree with me that relative to the total number of votes cast in even one election in North Carolina, 3 instances would be a very, very small number or percentage of total votes cast?
3 instances would be a low number. I mean, of course, I think as we discussed in the first deposition, if one of them flipped an election, we would probably have other ways of describing that. But 3 is a low number, um, for sure. As we, as I've said, these data sets that I'm drawing on are acknowledged by their authors to be incomplete. Professor Levitt has a very good data set. He's a leading academic opponent of voter ID laws, and he says that this data set's incomplete because obviously it's the nature of any crime of fraud to deceive, and so we have no expectation that prosecutions or even credible allegations would represent the universe of offenses for crimes of fraud.
Sure. And part of the reason why you say it's a valid exercise of the precautionary principle is for that very reason, that we may not know the full extent of impersonation fraud, correct?
We definitely don't know the full extent of impersonation fraud.
Okay. And that's a reason why, in your opinion, the General Assembly could have pursued voter ID as a legitimate solution, despite the relatively small number of credible allegations of in-person voter impersonation fraud, correct?
Yeah, the way I put it, I think, in the report is that SB 824, let's say voter ID laws generally, are consistent with the precautionary principle of regulation.
Okay, fair enough. Is it your opinion that it would be a legitimate exercise of the precautionary principle for a legislature to enact a voter photo ID law that intentionally targets African American voters?
The precautionary principle really doesn't speak to. I suppose I would need to know more about what the details of this situation are. Are you saying that there is some risk that the legislature is trying to guard against?
Let me ask it a different way. Does the precautionary principle justify a law that intentionally targets African American voters?
I'm not sure the precautionary principle justifies anything, actually. I would say the precautionary principle is a paradigm of legislation. So you could have a variety of different opinions on the merits of a particular exercise of the precautionary principle. All the precautionary principle says, I actually don't have my report in front of me, but I'll try to quote it from memory. All the precautionary principle says is that in the face of scientific uncertainty about the magnitude of a risk, that scientific uncertainty should not be an obstacle to action if the risk entails large or irreversible serious harms. So it
Okay.
doesn't say that you must act, not in the more modest form. It just is a paradigm of dealing with this fact of scientific uncertainty.
Okay. So assume with me that there's scientific uncertainty about the extent of in-person voter impersonation fraud. Okay. You've got that assumption in mind.
Yes.
And assume with me that the legislature believes the risk of in-person voter impersonation fraud is serious. You have that assumption in mind?
Yes. Yes.
If that legislature, with those two assumptions in mind, enacts a voter photo ID law that deliberately targets African American voters, is that a legitimate exercise of the precautionary principle?
I'm not sure about the word legitimate there. I think you're wanting the precautionary principle to do more work than it does. The precautionary principle doesn't allow wouldn't the precautionary principle doesn't necessarily allow us to distinguish between discriminatory or non-discriminatory regulations, right? So like there may be a discriminatory way to deal with um, the problem of any particular problem. There may be a discriminatory way to deal with it. There may be a non-discriminatory way to deal with it. We would need some other principles to help us choose between those different ways of dealing with it. The precautionary principle is actually not the principle that would allow you to make those distinctions. It merely says that the scientific uncertainty shouldn't stop you from regulating. So
Right.
it would have the precautionary principle would have, if I could personify it for a minute, it has no particular preferences between a discriminatory and a non-discriminatory form of regulation. I mean, that would be like, that just would be asking it to do more than what it is as a principle of regulation. It's not, it's not a principle of regulation that does its work on its own. There would be other principles, other norms like fairness and reciprocity that would also be, uh, applicable in a regulatory environment.
Right. But if I understand your report correctly, the precautionary principle is a reason why it is legitimate. It's a legitimate exercise of legislative power to legislate in an area despite uncertainty about the risk. Is that fair?
I don't use the word legitimate. It's a very it's a very heavy duty concept, moral concept. And ultimately, I'm not really making a moral argument in favor of voter ID laws. My section on that would be beyond my remit. My section on the precautionary principle is really doing something much more modest than that. It's saying that there's a well-established, widely recognized principle of regulation that's used in the European Union and in the United States that says scientific certainty is not an obstacle to action when you have an unknown risk of irreversible or serious harm. I'm sorry, large or irreversible serious harm.
Okay. But the fact that that is a well-known and widely used principle does not make a legislative action, to put it in your words, moral, or well, I'll just use your word, moral, if that same piece of legislation targets African American voters for discrimination, correct?
Absolutely not.
Absolutely, it doesn't make it moral, or absolutely?
No, if you have legislation that targets African Americans, the precautionary principle can't save it.
Okay, thank you. Now, another part of your opinion is that the General Assembly was justified in enacting SB 824 because the law could plausibly be expected to increase voter confidence, correct?
Again, I'll say I don't speak in terms of justified in enacting. So maybe this sounds like sort of social scientific hair splitting. What I say is that they cite an interest, promoting public confidence, and I ask a question. Is there any scientific basis for citing that interest? Or does it just have the character of a hope? And I find that there is some scientific basis for that interest.
Okay.
But I actually think it really would be a kind of question for practical wisdom or prudence, whether that is enough to justify. That would be a question, I think, and then I think this is where I end my report. That would be a question for policymakers.
Okay. And that's not a question that your report answers, correct?
No.
Okay. And with respect to whether or not there is a scientific basis for this interest in potentially increasing voter confidence, I think you testified this morning that's based on your review of the literature on this topic, correct?
That's right. Both Professor White and I produced literature reviews on this topic for this case.
Right. And you acknowledged this morning that the literature on this question is split, right?
It is.
Okay. And it's split between null results and studies that, in your opinion, show a positive relationship between voter ID laws and increased voter confidence, correct?
Yes.
And just to be clear, the null results are those that showed no relationship between public confidence and voter ID laws, correct?
That's right.
And in your canvas of the literature, you found two studies that you consider serious and well-designed that, in your opinion, support the idea that there is a positive relationship between photo ID laws and voter confidence, correct?
Yes.
And based on those two studies, you think it's reasonable to conclude that SB 824 may increase voter confidence, right?
Yes.
And your opinion is based on those two studies and nothing else, correct?
Well, it's also based on the absence of, a mountain of evidence to the contrary, right? So if we were talking about, if we had two studies, I mean, social science isn't just about counting heads, right? Because some studies just are better designed than others. But if we had, I mean, we could pick a number. If we said, here's 10,000 studies that show voter confidence has nothing to do with voter ID. on the other side, assuming that these are equally well-designed studies. But as you can see in my literature review, they're actually.
Yeah, let me just stop you right there. You sort of blipped out there for a little bit on my screen, and I suspect you did for others as well. So could you start that answer again? And
Sure.
I don't know, Ms. Fawcett, do you want to sort of let us know kind of where we were when he went out?
Sure. You said we could pick a number. If we said, here's 10,000 studies that show voter confidence has nothing to do with voter ID, and then you broke up.
So if you could perhaps start back along about those lines and finish
Sure.
your answer, that'd be great.
Sure, and maybe I'll be more concise before the next blip arises. So if we had a mountain of evidence on one side and a molehill other, well, then that would be a reason to be suspicious maybe of the molehill. But what we have is actually very few studies at all on this topic. I'm gonna just from memory say I think there are about 7, and the fact that we've got 2 well-designed studies that show that there's a relationship, 5 cross-sectional studies which I think have particular limitations that show a null result. I think leaves one with the conclusion that there is some support for the expectation that SB 824 may increase voter confidence.
Okay, and are you aware of any evidence that the General Assembly considered the 2 studies that you evaluate in your report? I have lost Professor Callanan. I don't know if others are having the same issue.
I've lost him too. Maybe he'll come back on in just a minute.
Your Honor, we are attempting to contact Professor Callanan to see if we can help him address this issue.
Okay, thank you.
Your Honor, this is Ms. Moss for the legislative defendants. I just spoke with Mr. Callanan. He says he can hear and see us just fine. He's not sure why his video and feed is cut off, but he's going to log out and log back in and see if that corrects the matter.
Okay, you might, many times when something like this happens, it's, I see now he's waiting in the lobby, so
And I have directed him to not have any other programs running on his program, and I believe, that he only has WebEx going. So
yeah, there I see him again. Professor Callanan, can you hear me okay now? Okay, I can't hear you. Maybe it's
I can hear you now. Yeah, I'm sorry.
Okay.
I've never used WebEx and there's nothing else running, so I'm not sure what's going on, but I think it's not time to sell my Zoom stock.
Well, it may not be just that nothing else is running on your computer. It may be that, and I don't know, you may know this too. I don't know if you're running your computer off of Wi-Fi, but if there are others on that network, that will lower your bandwidth and potentially make you blip out. So I don't know if there's anybody else on your system, but if you could perhaps tell anybody else to log off and give you all the bandwidth, that probably would help as well. And I don't know if there's a way for you to hardwire your computer such that you're not on Wi-Fi. That also may help. And this may be something for later on and get a little too technical, but the resolution on your video may also be able to be lowered such that it doesn't use as much bandwidth to see you. And I don't know if that's something that you're familiar with, but that also can help increase bandwidth for voice. And if
Okay.
we can turn your video off. I mean, it's nice to see someone testifying, but
Okay.
potentially we could turn your video off, but I don't want to go there yet.
Okay. I've alerted the authorities to stop using the internet upstairs. I don't think they are, but
Okay, fair enough. We'll go forward. Hopefully we'll be able to get through it. You may ask your next question. Or probably ask the last question you asked Mr. Brockman again, so we can get back where we were. Mr. Brockman, can you hear me?
I can. I was talking into a muted microphone. I apologize.
That's okay.
And Professor Callanan, my question was whether you were aware of any evidence that the General Assembly considered these two studies that you evaluate in your report.
and the answer is no.
Okay. And so turning to what I'm going to call the first of those two reports, the one from New Mexico, just to be sure that I understand the basic design, and I think you testified to this morning, there were some voters who were asked to show ID and other voters who were not, correct?
That's right. The law was differentially enforced.
Right. And then there was a random sample of those folks who were asked a series of questions, correct?
Yes,
And some of those questions were about voter confidence, right?
that's right.
And the study split up the questions on voter confidence into confidence that an individual voter's vote was counted correctly, and then confidence that all votes in the county were being counted correctly. And then the third category was confidence that all votes in the state were being counted correctly. Do I have that right?
That's right. Just to be even more specific, that's correct. Though they ask really three questions on confidence. Are you confident that your vote was counted correctly? Are you confident that the votes in your county were counted correctly? And are you confident that the votes in this entire election were counted correctly?
Okay.
So you could say three tiers of voter confidence.
Yeah. And is it your understanding that to the extent the study found a statistically significant link between being asked for ID and increased voter confidence, that was with respect to whether the individual believed that their vote was counted correctly?
That's right. It was what you would call individual level voter confidence. I'm confident that my vote counted.
Right. And that statistical significance did not extend to the question of whether the votes were counted correctly in the county or counted correctly in the state. Is that right?
That's correct.
Okay. And ultimately, the study concluded that voter identification policies appear to have little effect on models of voter confidence. Is that correct?
On the other, well, it has a null effect on the other two measures of voter confidence, null effect, but it has a statistically significant effect, positive, on individual level voter confidence. Individual level voter confidence is, previous studies have suggested that it is associated with some positive outcomes. This is, by the way, why political scientists study things like voter confidence or trust, because they're associated with other happy consequences. For instance, compliance with law or voter turnout. They're inversely associated with support for right-wing political, extremist right-wing political parties. So this individual level voter confidence has been shown to be associated with some advantageous outcomes.
Okay, but my question is just for purposes of this study, that individual confidence is differentiated from confidence in the county and statewide election results, correct?
That's correct.
Okay. And now the second study that you look at is from Virginia, and you testified this morning that it involves these mailers that provide information about Virginia's photo ID law. Is that correct?
Yes.
Okay. And do you know, did that study attempt to identify how people felt or what their confidence level was before they received the mailer?
No, that wouldn't be that wouldn't be necessary um, in an experimental design, because assignment to the treatment and the control group is random. So the reason you'd want to know, the reason you would ask how confident are you before you do your test, is that you'd be looking for a counterfactual. But in the case of an experimental design, the counterfactual is the control, because Virginians are being randomly assigned to these two groups. So if you want to know how confident are Virginians who don't get this mailer, the control tells you. You wouldn't need to ask them anything before they get the mailer, the ones that got the mailer. The control tells you what that counterfactual is.
Okay. But my question is simply for the folks who did get the mailer. There was
Yes.
no pre-question about what's your level of confidence in elections, right?
No.
Okay. The information campaign, these mailers, they influenced people's views differently based on party affiliation. Is that correct?
Yes.
Republicans' confidence in elections increased and Democrats' confidence decreased?
Yes. If you received the mailer and you were a Republican or a independent, you were significantly more likely to have higher confidence in the integrity of the election. If you received the mailer and you were a Democrat, you were less likely to have confidence in the election, although as the authors report, the decrease for Democrats is smaller than the increase for Republicans and independents. And as a result, the overall effect is to increase voter confidence in elections.
Okay. But assuming that the pattern or the result from this Virginia study were to hold constant in North Carolina, we might expect to see voter confidence amongst Democrats go down, correct?
Yes, I mean it's interesting to think about the implications of that. Right now, we have a situation in our country where Republicans and to a lesser degree independents have lower voter confidence than Democrats. So if the expectation was that Democrats' voter confidence would go down a little and Republican and independent voter confidence would go up a little, you'd end up with overall up more than that. You'd end up with overall higher levels of voter confidence and more parity.
But
But
assuming,
that's all making lots of assumptions about, exactly how this generalizes.
right. And so actually let's talk about that. So neither of these two studies that you rely on were conducted in North Carolina, correct?
That's right.
And to your knowledge, the voter ID laws in New Mexico and Virginia were not identical to SB 824, were they?
No, they were not.
Okay. And you did not compare features of those laws to SB 824 to try to ascertain the ways that they might be similar or different, did you?
No.
Okay. And you also haven't done any independent analysis to study ways that Virginia voters might be similar to North Carolina voters or different from North Carolina voters, correct?
Not specifically. I mean, we know let me give a broader answer if I may. The the question that you're raising is a good one. It's a question of what political sciences, social sciences generally call external validity or generalizability. And the question is basically, if we have a result in one context, how confident are we that it is generalizable to another context? And the closer the two contexts are, the more we would have an expectation that an internally valid result would be externally valid. So with states like Virginia and North Carolina, neighboring states, similar, I mean, within the same country, within the same region of the country, not radically dissimilar demographically, we wouldn't have any obvious reasons why we should be certain that the result is not generalizable. I mean, frankly, the question of whether a result from Virginia generalizes to, may generalize to, well, let me put it this way. The assertion that a result from Virginia may generalize to North Carolina in political science is not a controversial assertion at all.
Okay.
To say that we're sure that it generalizes, it would be controversial. But
Sure.
to say that it may generalize is completely uncontroversial.
Okay, but my question is simply whether you've done any independent analysis of differences or similarities between the electorates or the voter ID laws that might affect that question of whether the result is generalizable.
Well, you asked earlier about the voter ID laws. I didn't compare Virginia and North Carolina's laws because of this study, but I have compared Virginia's voter ID law to North Carolina's voter ID law. In fact, the voter ID law that was in place at the time, it was a strict voter ID law actually in place in Virginia at the time.
Okay. And you have not analyzed explicitly in your report, and you're not offering an opinion on whether, to use your words, whether it's certain or whether it's highly likely that the results from New Mexico or Virginia are generalizable to North Carolina, are you?
I wouldn't say certain. I would characterize it as a reasonable expectation.
Okay.
Given the political demographic similarities, given the fact that we're talking about the same kind of voter ID law, photo voter ID law.
Okay. Fair enough. And just to be sure that I've got, I think, the complete answer, you haven't done an independent analysis of differences or similarities between electorates across these three states, correct?
No.
Okay. And if you actually wanted to measure whether a voter ID law in North Carolina affected public confidence in election integrity, you would need to conduct some kind of a retrospective study in the state. Is that correct?
The best way to do it, I think, based on the existing research, would be to do an experiment, either a field experiment or a natural experiment, like the New Mexico or Virginia study. You couldn't do it while the law was enjoined, but but you could do it if you had one of those opportune moments as the Virginia researchers. I mean, they're not from Virginia, but the researchers did the Virginia study or the New Mexico study had.
Sure. And you haven't, I take it from your prior answer about the law being enjoined, you haven't conducted such a study in this case, correct?
No, nor could you.
Okay. And Professor Callanan, you would agree with me that if a voter ID law disenfranchises voters, we could reasonably expect that law would have the effect of reducing rather than increasing public confidence in election integrity, correct?
I haven't given a lot of thought to that question. I mean, it's a good question. My initial inclination is to say if you had a law that was, disenfranchising a significant number of voters, I certainly think it would that would be a hypothesis worth testing.
You don't recall testifying that any law that disenfranchises voters, any election regulation that disenfranchises voters, one would have a reasonable expectation that that law would have the effect of reducing public confidence in election integrity?
If the disenfranchisement were on I mean, we could split hairs here. We could say, look, if we're disenfranchising 2 voters, then no. But if we're talking about a significant amount of disenfranchisement, then that would be a reasonable expectation.
And if a law intentionally targeted a particular group of voters in a discriminatory way, that would also, you would reasonably expect, would have the effect of reducing public confidence in election integrity?
That would be a reasonable expectation. I mean, these are ultimately hypotheses, but they would be theoretically appealing hypotheses.
Professor Callanan, I have no further questions for you at this time, subject to any additional questions from your counsel. I appreciate you being here today.
Thank you, Mr. Brockman.
Mr. Cox, you may cross-examine the witness.
Professor Callanan, I just have one clarification question for you, or perhaps a series of clarification questions. And for the record, this is Paul Cox from the Attorney General's Office for the state defendants. Do you recall in your cross-examination being asked a question about whether the Fourth Circuit had invalidated the prior photo ID law, HB 569?
I do.
And do you remember you were asked whether the Fourth Circuit invalidated that law? Well, let me start again. Do you recall that you were asked whether the Fourth Circuit found that that law was intentionally discriminatory as amended?
I do, and I believe I hesitated at that because I have some recollection that, at least intellectually, I hesitated at that because I have some recollection of the reasonable impediment amended not being fully absorbed into the judicial reasoning.
No further questions, Your Honor.
Redirect examination by Mr. Patterson.
Yes, thank you, Your Honor. I have a few questions for Professor Callanan on redirect. Professor Callanan, on cross, you testified that a constitutional amendment was not required to give the General Assembly the authority to enact a voter ID law under North Carolina law. Is that correct?
I believe that's correct.
And although a constitutional amendment was not required, given the circumstances confronting the General Assembly, do you think it was unusual for the General Assembly to have put the voter ID constitutional amendment on the ballot?
Could you repeat your question, Mr. Patterson?
Yes.
I'm sorry.
Yes. Understanding that a constitutional amendment was not required for the General Assembly to enact a voter ID law, do you find it unusual, given the circumstances confronting the General Assembly, that it decided to put the voter ID constitutional amendment on the ballot?
No, I don't find it unusual. And I think, just to nuance that prior answer, I think, if I recall my exchange with Mr. Brockman, he asked me, I first, I think, said that I don't have an opinion on whether it was constitutionally required to do a constitutional amendment. But then I think he said, from a sort of procedural legislative point of view, was it constitutionally required to do the amendment? And I said, or was it required to do the amendment? And I said no to that.
Right, correct. And then so, although it wasn't procedurally required, I just want to make clear, you don't find it unusual that despite the lack of a procedural requirement, the General Assembly nevertheless put that question to the voters in the form of a constitutional amendment?
I don't. I mean, it's you can find examples of legislators looking essentially for what you might call a kind of backstop, right? So that they want to be sure that the law that they're passing is constitutionally sound. And so you might pass a constitutional amendment that you don't necessarily know for sure is constitutionally required. Maybe you may not even think it is, but you may be using it as a kind of backstop. I mean, it's actually a very interesting, from a political science point of view, it's a very interesting kind of feature that's in which the sort of separation of powers dynamic is implicated.
And Professor Callanan, on cross-examination, you were asked several questions about the rational actor model of legislative behavior. Do you recall that?
I do.
And I believe you testified, but if I get this wrong, please correct me, that if one assumes the General Assembly had an objective of entrenching Republicans, then it is possible that acting in the lame duck session to make it harder for African American voters to vote would be consistent with that assumption about the General Assembly's objective if African Americans tend to vote for Democrats. Is that basically the substance of your testimony?
Yes.
Now, how does the fact that 20% of Democratic senators who voted on SB 824 voted in favor of the bill affect the plausibility of the assumption that the General Assembly's objective was to entrench Republicans?
You wouldn't normally expect a bill that is designed to entrench Republicans to garner bipartisan support.
And how does the analysis you did of the terms of SB 824 in comparison with other state voter ID laws affect the plausibility of the hypothesis that the General Assembly was intending to make it harder for African Americans to vote because they tend to vote for Democrats?
Well, we could begin with maybe my mind goes to the last piece of my report. So the General Assembly chose to craft one of the most accommodating free ID regimes in the country among photo ID states. It shares, I believe, with one other state the feature of allowing voters to get IDs in two different kinds of state agencies, and to get these IDs at least in one state agency without supporting documents. So, all other things being equal, that's not the kind of free ID regime we would expect if a legislature is bent on preventing people from voting. You can't rule it out simply on that basis, but it's not what we would expect.
And I believe you also testified that other norms could impact the rational actor analysis. Is that correct?
Sure.
And is the prohibition on racial discrimination under the Equal Protection Clause of the U.S. and North Carolina Constitutions one such potential norm?
Yes, it's rational. One of the things that it's rational for actors to do is to take into account all of the constraints on their institution and on actors within the institutions. And certainly fundamental law is one of those constraints.
And is the fact that North Carolina's prior voter ID law had been struck down under the Equal Protection Clause consistent with an expectation that a rational legislature would be particularly attuned to the need to avoid racial discrimination in the enactment of SB 824?
I'm not sure I have any off-the-cuff judgment on that point. It's just there's a number of pieces there that would take time to digest.
Okay. Now, in cross-examination, I believe you testified that Senator Ford was the only Democrat to vote to override Governor Cooper's veto of SB 824. Did you mean that Senator Ford was the only Democrat in the Senate to do that?
I don't specifically recall. I know that what I do specifically recall is that the two other Senate Democrats did not vote to override. I don't recall the roll call in the House.
Okay, well, if we could bring up JX 646, which is the House roll call vote transcript on the veto override. And if you look under the I votes at the bottom of that page there that's up on the screen, it has one Democrat listed, Dwayne Hall. Is that correct?
Yes.
And does that refresh your recollection that a Democratic House member voted to override the veto, SB 824?
Yes. Yes, it does.
And Mr. Cox touched on this, but I'd like to bring up LX 145, which was the Fourth Circuit's decision addressing HB 589, the prior voter ID law. And I'd like to go to page 305. No, I'm sorry. This is a different. So this is a different. I'll get to that later, but this is a different document. This is the Fourth Circuit's decision on the preliminary injunction of SB 824, this law. Were you aware that the Fourth Circuit had reversed a preliminary injunction against SB 824 in the federal court litigation?
Objection, Your Honors. Is this redirecting anything that was within the scope of the cross-examination?
I can speak to that if you would wish.
Well, if you want to be heard about it briefly, I'll hear your response to his saying it's outside the scope of cross.
Yes, he had crossed him about the North Carolina Court of Appeals decision on the appeal of preliminary injunction, and I was just wanting to ask him about the Fourth Circuit's decision on the appeal of the preliminary injunction in that case.
Give me 1 second. The objection sustained.
Okay, I will move on then. So now I would like to bring up JX 838, and this is the Fourth Circuit's decision on HB 589. And I'd like to go to page 240, which is on PDF 28. Okay, and there's a 31 paragraph heading. It says, moreover, the fact that the General Assembly later amended one of the challenged provisions does not change our conclusion that invalidation of each provision is the appropriate remedy in this case. Specifically, in 2015, the General Assembly enacted SL 2015-103, which amended the photo ID requirement and added the reasonable impediment exception. Does this refresh your recollection about the Fourth Circuit not incorporating the reasonable impediment amendment completely into its analysis and striking down HB 589?
It does.
And under HB 589, was it possible for a voter to get a free ID without presenting documentation?
No.
And was it possible for a voter to get a free ID without documentation from a county board of elections during early voting under HB 589?
No.
And I would like to publish next, Your Honor, since Professor Callanan was asked about what the legislature considered during enactment of SB 824, and I'd like to publish JX 863, which is one of the legislative privilege documents that was ordered to be produced and that we are waiving confidentiality on for purposes of publishing it here. Hearing no objection, I will continue. Professor Callanan, I'll represent to you that you see here, this is a draft bill. Let's scroll up to the top, please, if we could. General Assembly of North Carolina, it says bill draft. It's dated November 15th, 2018. Do you see that, Professor Callanan?
I do.
Okay, and if we scroll down now to the beginning text, there's language highlighted in yellow. It says the language in part 1 directly tracks the SC statute to the extent possible. Small changes were made for clarity, conforming changes to NC drafting style, removal of redundancies, and when other procedures in SC election law did not fit with NC procedures, those are noted within. Professor Callanan, is this consistent with what I believed you testified, that it would be normal to expect a legislature to be aware of and cognizant of other voter ID laws when enacting its own voter ID law?
Yes.
And I would like to bring up one more similar document. That's JX 860 or 857. And this is another one of the legislative privilege documents for which we are withdrawing confidentiality on. And if we scroll down, you see, let's scroll up a little bit so we can see the people on this email, the second email. So we've got ncledge.net email addresses, legislative analysis titles, and if we go down to the text, it says attached is a copy of the rough draft we have started for voter ID. This incorporates in the 2011 South Carolina legislation H 3003, including the 5 specified types of ID. Now, is this also consistent with your understanding that the General Assembly would be cognizant of other voter ID laws?
It is.
And it says here specifically that the South Carolina legislation has 5 specified types of ID. And to your knowledge, does SB 824 have more than 5 specified types of ID?
Yes.
And so is that consistent with a conclusion that the General Assembly intentionally extended the forms of ID beyond what is available in South Carolina?
If there are more IDs, then it was certainly done intentionally in some sense.
Okay, I have no further questions for you at this time, Professor Callanan. Thank you.
Thank you, Mr. Patterson.
Mr. Brockman, do you have other recross?
I do not, Your Honors.
Mr. Cox, do you have other recross?
Oh, thank you, Your Honor.
I believe there may be some questions from the court. I'll turn it over to Judge Ofalu for his questions.
Good afternoon, Professor. Can you hear me okay?
I can. Good afternoon, Your Honor.
Yes, good afternoon. I wanted to just orient you to the place where I have a question or two. Mr. Patterson had asked you questions about the NCSL document. I believe it was JX 873 about strict versus non-strict ID laws. Do you recall those questions?
I do, Your Honor.
Ms. Hardman, could you bring up JX 873 just so Professor could know where the questions are? And specifically, if we could go to page 5 of 873, I think it's page 5 of 26. That's it right there. I just want to make sure that I understand your testimony, and just please feel free. I'm not trying to put words in your mouth. I'm just trying to make sure I understand that the difference between a strict and a non-strict identification law is whether it requires the voter to do something in addition to merely going to vote, they have to return and do something else. Is that correct?
That's correct, Your Honor. There's some action that has to occur after the visit to the polling station. In every instance, it's not necessarily that you have to return, although I think for the current physically, although I think for the current strict ID states, you have to physically return. Virginia once allowed you to, once required you to fax in a copy of an ID, but all the others, if memory serves, actually require some physical action in order for your vote to count.
So is that the only distinction between strict and non-strict, the fact of some other action in addition to the mere appearance? Is that the only criteria?
That's exactly on this taxonomy. The only difference is some action after your visit to the polling station must be taken. You can't have what you might call one-stop voting.
Okay. So here, therefore, is my question. In this, as you can see on the screen here, there is a strict category, and it's divided into photo ID and non-photo ID, and it has 3 states there: Arizona, North Dakota, and Ohio for non-photo ID under strict. Now, we don't need to get into the weeds about, what the differences are between those 3 states, but my question is, what if you're in a non-photo ID state and it's strict, what does that mean?
Your Honor, it means that if you don't produce compliant ID, and in this case, there's for non-photo states, at least one form of the ID of the compliant IDs are non-photo. If you don't produce compliant ID, you need to take some action after your visit to that polling station. So, for example, maybe you're allowed to use your social security card, and that's the ID you intended to use, but you forgot it. You have to go get it and bring it back, or you have to go get it and cure your ballot at the county board of elections in 24 hours or 48 hours or 2 weeks. But
Okay.
It's the same distinction.
Okay. So the non-photo ID, there could be a wider array of conforming IDs or conforming documents. It could be a power bill, or it could be your social security card, or it could be your your employment ID. There could be a wider array in the non-photo ID strict states.
That's exactly right, Your Honor. There could be a wider array of IDs, one of which you would have to do something with after forgetting it to vote.
Okay. So to put it another way, just because something is strict doesn't necessarily mean that there wouldn't be a wider array of conforming documents that would allow a registered voter to vote.
That's right, Your Honor. You in the terms of my report, you could have a state that is strict in its approach to voters who show up without ID, but it could be flexible in its approach to crafting a list of compliant IDs, or vice versa. You could have a state that's not non-strict but inflexible.
Okay. So in other words, to put it nicely, from a social science point of view, the words flexibility and strict are not the same.
Not as I'm operationalizing them.
Right. Okay. Thank you so much, Professor. I appreciate you being with us. Those are all the questions I have.
Thank you, Your Honor.
We have some other questions, but it's now 3:34, and we're going to go ahead and take our afternoon break, and we'll come back with more questions, perhaps from the court. But it's about, I'm going to call it 3:35, and so I try to stay right on schedule with these breaks. Forgive me for doing that, but it keeps us on schedule. And we've been in here for an hour and 35 minutes now, so we're going to take a break between 3:35 and 3:50. We'll come back at 3:50 p.m. Thank you very much.